Take you back to our top story today, where that second docket in the Senzo Meyiwa murder trial is continuing to dominate proceedings. You may have seen earlier we were recapping some of what's been said by Advocate Mnisi, who is the defense representative for accused 1 to 4. Let's get you a live update now from our reporter Linda Mnisi, who's joining us from the High Court in Pretoria. Linda, so the main focus was meant to be fixing dates for when the trial resumes with cross-examination and the rest of it. But Advocate, therefore, is determined, of course, to flesh out more of his problems that he has with the handling of that second docket.
Yes, indeed, Tembegile. And today we heard him saying that he would be addressing the court based on new submissions and new instructions that he received from his clients, kicking off the proceedings, of course, with addressing the issue around how he obtained the 375 docket. You'll remember that he's said to be the only one that was in possession of that 375 docket. And he says that there was an impression that was created that due to his past and him being a former police, he may have been able to obtain that particular docket, and he says that that is not the truth. In fact, he details how he got that docket, and saying that in fact he got it on the 23rd of March, and that Advocate Baloyi, who is the prosecutor in this matter, had been in possession of that docket since January 2020. He goes on to also address the issue around the letters that we heard in court yesterday being read out. Those are the letters that were providing clarity on the status of that particular docket, which was coming from, or were coming from, the DPP in the South Gauteng division. Saying that, in fact, the author of that particular letters is not the one that is listed there, Advocate Tauke. He says that, in fact, there's someone else who authored that particular letter, going as far as saying that, the junior that is listed in that particular, letter is not in fact a junior. It is a senior advocate who is based in the High Court. But of course, you would have seen, Tembegile, a number of interjections from particularly the state, saying that these are issues that were supposed to be brought into the court by way of affidavits and following proper procedures. But that seemingly was not what Advocate Mnisi was going through. But the judge coming back to say, but these are submissions that were being heard over the past hour or two, and none of the counsel stood up to interject and say that this is not the proper way of introducing evidence to the court. You would have also seen Advocate Mnisi introducing, an affidavit from an investigator that says that Kelly Khumalo was supposed to have been arrested with the people who are in the dock. So all of those issues that he seems to be unhappy about, raising them as way of evidence from the bar, which is procedurally, according to the legal representative, not how things should have been done. We heard from Advocate Mshololo, who is one who was requesting a lengthy postponement in this matter, weighing in the way that Advocate Mnisi has been doing things and, introducing evidence in this particular court before she could even conclude her own cross-examination. Let's take a listen to what Advocate Mshololo had to say.
This is very unfair, my lord, and it is unprecedented into our law that when a counsel for another accused is in the middle of cross-examination, another counsel will bring an application, whether it's on jurisdiction or whether it's on constitutional violation, my lord. But the 10, as the court has been repeating, that the 10 for my learned friend is coming, my lord. But at this time, he ought to have respected me and afforded me an opportunity to finish my cross-examination before he could bring the submissions he has made, my lord. And on that point, my lord, the fact that we have sat down and not objected to the submissions made, it does not necessarily mean that what has happened is right. It is wrong in law, it is unprocedural, whether objected or not objected, and it's inadmissible before this court. And it's a waste of time, my lord, at the time when I'm supposed to be dealing with critical issues pertaining to my cross-examination. My lord, I submit and I ask with due respect that these proceedings be stopped at this point in time, and then we adjourn the matter as I have asked this honorable court yesterday, that the proceedings should be adjourned to the date that will be suitable between ourselves and the role coordinator to allow the defense counsel, my lord, for accused number 5. That must be clear on record. to proceed with cross-examination.
So that's Advocate Mshololo really responding to, the events that took place today. As you would have mentioned earlier on, Tembegile, that today was set down to really look at the postponement and the dates around the submission of papers and responding affidavits, as well as the submission of heads of arguments. But we saw, towards the latter part of these proceedings, to a point even where, instructing attorney T.T. Tobane having to intervene between an exchange between, the judge as well as Advocate Malesela Tefo, for the manner in which the judge says he could have waited. He could have waited for, all the legal processes to unfold, and when it is his turn, be able then to make those submissions that he feels were not done procedurally, or there was a cover-up that was involved in this particular matter. Let's take a listen to that interaction between the judge and Advocate Malesela Tefo when he was in fact being told and schooled on the procedures of court.
Your Lordship, as we say, Your Lordship, and the Holy Book says, you see the stick in your brother's eye, while there's a block in your eye. This is what is happening with the DPP. He's the last person they can talk about the procedure, Baloyi. There's a corruption happening in the office of DPP. Why we have the two dockets today?
Which means
it's
you have many points for appeal. If the wrong decision is taken, you have so many. You are not wanting. And
so many
the way things happen here, even if it's very unfair, the procedure binds us to hold back and wait for the right time. If we are practicing law, unless we are practicing something else.
I've heard that my learned colleague, in particular, Mshololo, has been so sarcastic. One can be sarcastic as much as she wants. I'm not interested in that, sarcasm. I'm interested in fighting the constitutional rights of my client, 1 to 4, in this court. Because they are before this court unprocedurally.
But Linda Mnisi, we'll come back to you when court resumes after lunch. For now, thank you very much for that update from Pretoria.